it please the court, I would like to reserve 5 minutes for rebuttal if possible.
Okay.
Thank you.
You need to state your name for the record, too.
Yes,
please.
sir. Stephen Giesler. With me is co-counsel Nicholas Giesler, Giesler and Giesler, Stuart, Florida, for the appellants. May it please the court. The foundation for the appellant's argument in this case is twofold. They are pled in the alternative, and as stated in the briefs, the plaintiff or the appellants, the plaintiffs below, need only succeed on one of these two foundations to succeed ultimately in the case. The first of these is that the comprehensive and exhaustive statutory scheme regulating docks on sovereign submerged lands, the authority pursuant thereto is exclusively within the purview of the state. The Department of Environmental Protection is the sole authority when it comes to regulating these docks on state-owned sovereign submerged lands. And that because this authority is of this exclusive nature, that the city's ordinance is invalid and must fail. The second, and somewhat related, but again mutually exclusive and independent foundational argument, is that even if the city's home rule powers under Chapter 166 do grant it concurrent power with the Florida Department of Environmental Protection to regulate these docks, that the ordinance must fail because that authority conflicts with the superior state authority. That the prohibition of docks on this swath of land in which all the appellants reside conflicts pursuant to state law, and specifically the test elucidated by the 3rd DCA in Rocio versus City of Miami Beach in 1981, and adopted and followed by this court in several cases over the 30 years since.
Well, Rocio, that regulated condo conversions. That's where a city ordinance conflicted with the state law, and there were various factors, enumerated factors, where it was inconsistent with state law and prohibited certain things that state law allows.
Absolutely, Your Honor.
I mean, this case is, as I see it, there's a 1993 ordinance. About 16 years later, your clients buy the property. This ordinance applies to a very limited defined area on Sanibel Island, which you would agree is in the city boundaries.
It is. It's within the corporate boundaries, yes.
And are you arguing that the DEP through the state, with permission of the Board of Trustees, that once they permit a dock to a private landowner, that is an unqualified absolute right to build a dock anywhere within a city boundary?
It is unqualified with the exception of those qualifications that are in the authorization itself.
But I don't see where there's any federal or state preemption here.
It's not, well, I'm sorry, please, Your Honor.
I don't see any express preemption in here. Would you agree?
No, and in the briefing, one of the arguments is that Chapter 373.023 is an express preemption. And
It's a chapter on water supply.
It's a chapter on water quality, and what it says is that, and it refers to surface waters, and the surface waters are later defined as encompassing the waters that are involved in this case, that any regulation, any local ordinance that regulates, that affects, not regulates, that affects water quality must be filed with the state prior to.
Well, let me start with a simple proposition then, because this talks about affecting water. This ordinance prohibits a dock. I see absolutely no adverse effect on water by prohibiting a dock. So how is that inconsistent?
It actually does not have to adversely affect. Any effect whatsoever we would argue, expressly preempted by Chapter 373.
Well, then it would be a beneficial effect.
That would not matter pursuant to the statute. However,
see, what I see throughout this statute is, and you forced me to read this, and I now know all about DEP and all these rules and regulations,
right.
And I appreciate that because I've learned a lot.
Right.
But the broad scheme of all of this legislation is, protecting the water, conserving water, stormwater, solid waste, wetlands, preventing certain obstacles in navigable water, making water suitable for public use, et cetera, et cetera. Now, any references to docks, particularly private owners having docks, is de minimis. Plus, hold on a second, plus when you talk about the delegation by the DEP to certain local governments, but subsection 4 of 373-441 provides, this section does not affect or modify land development regulations adopted by local governments to implement its comprehensive plan. That is clear. So it seems to me the legislature knows how to preempt things. And they have. There are certain provisions in here where it says, you know, the city can't construct islands and extend lands in navigable waters. That's clear prohibition. But there's no clear prohibition within this statute anywhere where the city's zoning laws cannot have an effect on the private property's owner's permission to build a dock.
Let me start at the beginning. Chapter 373 and 403.813, the entire comprehensive scheme has to be read in the context of chapters 253 and 258. 253.001 particularly states that DEP's responsibility, as DEP was afforded the regulatory authority by the state to regulate properties owned by the Board of Trustees of Internal Improvement, to regulate sovereign submerged lands. It's not just to protect the environment, which is certainly one of DEP's, it's stated in its name, one of its chief goals. It's also to balance the rights of upland owners, which are the rights that are inherent to the property owners in this case.
But is this really a right to build a dock or just permission?
It's a right. It's a qualified right.
It's an absolute right.
It's not an absolute right. It's a qualified right.
But isn't it subject to existing zoning laws wherever you want to build a dock?
It is not, Your Honor.
Why not?
Because the exclusive authority, it's for two reasons. One, because as we've argued in the briefing, this authority resides, but based on the statutes and the regulations, solely within DEP's ambit, and that's argued. This is a question of first impression, so it's argued by reference to the delegation agreement. It's argued by reference to the authorization from DEP, which mentions the need to comply with DEP's regulations. This is at pages 350 to 356 of the record, and I think probably those, other than the ordinance itself, the most important pages in the record. This authorization from DEP also references permission from the Board of Trustees, the sovereign owner of the property. And furthermore, it references permissions needed from federal regulators. It references what the deleterious effects of what could happen if you don't comply with those regulations. There is no reference whatsoever to local government authority.
So there's a deleterious effect to the water.
No, Your Honor.
If I allow you to build a dock. Right? No, don't allow you to build a dock.
No, Your Honor. The effects, the penalties that could be suffered by the owner if he or she were to build a dock without complying with these certain regulations. The second reason for the argument, when we would argue that it's a fact that the authorization is not subject to local zoning, is that even if you set aside preemption or express preemption or implied preemption, you still have the doctrine of conflict. And under Rocio, we've argued in the brief that there are
I don't understand how a zoning rule, I mean, admittedly, if it authorized the building of the dock, that would conflict with Florida law if Florida law said no, you can't build it. But if the zoning law is saying we don't want this, even though you could build it under these forms of regulations, we've got a pretty downtown and we just don't want docks cluttering up our pretty downtown area for a quarter mile either direction. How does that conflict?
It conflicts in this sense. There are several different tests that govern conflict law in Florida, as I'm sure the court's aware. One, then this is the test that is pointed out and relied upon by the lower court, we would argue in error, is if there's a conflict if one law, if the interaction between the two laws, the local ordinance and the state statute, require a person to violate one in order to comply with the other. That is not the test here. The test here, pursuant to Rocio and its progeny, is this, that where a local ordinance prohibits activity that is licensed or permitted by the state, it's an impermissible conflict and the local ordinance must fail. And the analogy to the condo law in Rocio is actually fairly on point in this case. And the reason is, in the city of Miami Beach, this is 1981, I was not around for this dispute, but apparently there was a housing boom and there were concerns about the speed with which people were condominializing property down there. And so what happened was the city passed this ordinance that said we're going to have a more restrictive test for allowing you to establish a condominium. And the property owners in that case, this is the city of Miami Beach, the property owners in that case said no, that the exclusive authority in this realm is Chapter 718 of the Florida statutes. You can't have a more restrictive test for whatever reason, whether it's to protect ambiance or if it were environmental concerns, just rampant growth, whatever the concerns were there, that they're not relevant because this exclusive authority exists and the subordinate authority from on behalf exercised by the city in that case excluded or prohibited activity that the state licensed.
And was that a preemption or a conflict case?
It was both. The third DCA in that case ruled against the property owner on preemption, but for the property owner on conflict.
Express or implied preemption?
It was both. I believe that the chief was...
To me, if you've got express preemption, all these other things become footnotes in the analysis.
Correct, Your Honor.
We don't have express preemption in this case, from what I can see.
We've argued it. We think that 373.023 is sufficient to find express preemption. However, and this is reflected in the amount of attention that's paid to the issue in the transcript of the lower court's hearing on summary judgment and in the order below, we would argue that the conflict case is actually stronger. And it's for that reason that despite the importance that we're placing on this here, it's placed last logically or thematically in the briefing. And that's because we're going from a more broad doctrine, which is that of express preemption, to the narrower subordinate doctrine of implied preemption, and then finally the most narrow, which is conflict preemption. But the test that is elucidated in Rocio, or I guess it's announced in Rocio and has been elucidated by this court in Dulce in 1984, and then again in Browning, the Sarasota fair election case in 2007, Rocio governs here. And despite the doctrine of conflict being more narrow than the doctrine of implied or express preemption, the test here, which is, we would argue, governs this case, is actually grants greater consideration to state authority.
Well, the Rocio case was decided on conflict because this particular ordinance contradicted with what state law provided. This ordinance prohibited recording of declaration of condos for 90 days, and the state provided otherwise. It made it unlawful to convert a rental apartment for 90 days. The state law provided otherwise. It also gave the city the power to enforce prohibition against creating condos instead of the division of the Florida land sales, which was set up by the state. That is a clear conflict. Here, the state gives you a permit to build a dock, which in no case law is it an unqualified right. The city says you can't build it here. I fail to see a conflict because they're not requiring your clients to take any action which would violate state law. Where's the conflict?
The conflict is perhaps the Rocio test should be deemed a fourth class, something separate than a traditional conflict where what you just mentioned, Your Honor, there is no requirement, as in a traditional conflict case, that compliance with one rule requires violation of another. And I think that would probably be most evident in some sort of criminal proceeding, traffic lights or of the such. This is a separate class of cases, which is, aside from preemption, aside from express or implied preemption, and aside from that type of conflict, the rule set forth, the test set forth in Rocio is clear that where the state permits, and it doesn't have to be a right, either qualified or unqualified, that where conduct is permitted by the state or authorized by the state but is prohibited by a local government, the local ordinance must fail.
So I got a hunting license for deer in the state of Florida. They say I can get 2 this year. Tampa says, as a statute says, no hunting in Tampa. Can I shoot deer in Tampa?
Is the hypothetical that this is on state-owned property, or is it property that's privately owned or owned by the city of Tampa?
You're got private property in your case, private property in mine. I got 2 deer in my front yard and I want to take them out. Can I? And
Well, there is
Tampa
not
has a no hunting ordinance. Is that ordinance in conflict in some fashion with the state?
If it's on state-owned property, and that's important here, because the fact that the state owns this property,
Only owns part of it.
it owns all the property on which the dock is going to be built, and this ordinance
So
is
you're not gonna build, these various people, Doctor whatever his name is, not gonna build any dock on his own property?
the dock would be, the dock, the upland portion of the dock would be appurtenant to the dock that is built on the sovereign submerged lands. But I would,
Okay.
so I would argue that the fact that the state has, through the Board of Trustees, afforded this authority directly and exclusively to DEP to regulate these, or to prohibit, if it chooses, these docks on these sovereign submerged lands, if the state owned the property in your hypothetical, then yes, I would say that they do have that there is a conflict.
Okay. You're at 15 minutes.
Okay,
so.
thank you.
Mr. Hemke?
Yes, Your Honor. May it please the court, my name's Don Hemke with Carlton Fields. I'm here on behalf of the City of Sanibel. With me at council table is Ken Kyler, the city attorney for the City of Sanibel. Basically, this is a case which is the trial court judge, Judge McHugh, has a very extensive order where he analyzed the conflict issue. And this court has said that the test in a conflict is whether complying with one violates the other. That is what this court basically said in the Browning Sarasota Alliance for Fair Elections cases. Judge Valenti said that then. The Polk County Builders case, Judge Valenti's concurring opinion. It is also, in fact, this court, even in the Sarasota County case, Browning v. Sarasota County, this court said that that is the sole test. This court's not the only court who basically says that that is the test or that is the sole test. We've outlined those in the brief. The 3rd DCA, there's a series of 3 cases from the 3rd DCA that speaks in terms of the sole test. There is no conflict here because what the state says, the legislature, and it's got to be a conflict with a statute or legislation, not because a state bureaucrat permits it down the chain at some point in time. But what the state legislature says is that the DEP, which has been delegated to them, may grant a permit. They may not grant a permit either. It's permissive with them. It's not mandatory. It does not create a right. And in fact, this court, in an en banc decision, Judge Altburn wrote back in 2007 by name of Brannon v.
That case must just stand by itself.
Absolutely, but very clearly the language there, very clearly the language which 10 of your colleagues concurred in, very clearly says that a dock is basically an illusory right until you get zoning. And that was picked up by Judge Black in a later case 2 years ago in 2013, and it goes back to a prior decision of this court by the name of Kartesh back in 1961, if I recall correctly, some time ago. And there is just no conflict there. Zoning is a fundamental right, going back to Ambler v. Realty Company versus Village of Euclid back in 89 years ago, and the U.S. Supreme Court, as well as the courts of Florida, have recognized that zoning may protect aesthetics, may protect the ambience of a community, the character of a community, in similar to what you were saying about downtown. If you don't want docks downtown, that's part of the zoning power. This is within the territorial limits of the city of Sanibel, which goes out a half-mile water side into the water from Sanibel. That's been delegated to them. There is just no conflict there in that scenario. What the state permits, basically, state does not grant a right. In fact, we were up here, went on a parallel track because the federal issues went up Middle District to the 11th U.S. Court of Appeals, to the United States Supreme Court, just denied certiorari in January of this year. And there basically, one of the issues was, is there a right, a property right to a dock? And the answer was no. There is no right to that. There's no, it's a qualified right at best, so that there is no conflict. The cases where conflict have been found, just very, very few and far in between. I will address the implied preemption argument just briefly. For implied preemption, there's got to be so pervasive, basically, that you need one size fits all rule for every place in the state of Florida, and that's what they're suggesting, basically, is that there is this one rule, which they would contend, which comes down from the state, that everyone's got to permit docks there that way, one size fits all, and that just can't be the law. In the record here, there's 51 local governments, municipalities, coastal municipalities, which either regulate or restrict or ban docks, and basically to accept their argument here would invalidate not only Sanibel's restriction and prohibition, but that there's 9 other prohibitions, and there's 42 ones which regulate it somewhat, and basically would make those also subject. And I tend to read cases. That's what I do for a living. I know that's what the court does here for a living, going back to law review days a long time ago. And there's 25 decisions that we've been able to find where implied preemption has been argued in the Florida appellate courts, and only one time, basically, in conjunction with the public records in Chapter 119, has there been an appellate sustaining of an implied preemption. That takes care of the implied preemption. Insofar as the express preemption argument, there's just nothing there. And in the contrary, sometimes attorneys, courts, I read what they say focus on the statute. And the statute here, which is on page 18 of our brief, which goes towards many of their arguments and undercuts it. And this is the argument which basically is chapter Florida Statutes 403-813-1, which is basically the delegation, the provision under which they're operating, down from trustees of the Internal Improvement Fund to DEP. This is what they're acting on. What they, in fact, say is the statute which is applicable, right on page 1 of their brief. And the statute, if you would look on page 17 of our brief, I apologize, I'm off a page, would basically says, it says at certain times you don't need a permit if certain conditions are met. But what the statute says, and the Florida legislature says, however, nothing here shall excuse, quote, complying with applicable local pollution control programs authorized by this chapter, being if they're delegated some power to enforce environmental provisions, but here we're talking about zoning, which is much broader than environmental, or other requirements of county and local governments. Basically, rather than restricting local power, the Florida legislature in that particular statute, 403-813-1, basically recognizes, it blesses the local power there. And of course, they need not even have done that, because since 1968, with the Constitution going into effect at that point in time, the new Constitution, 1973 with the home rule power, and the cases are legion that basically say that it's no longer a question that delegation must come down from the state to empower local governments, but rather what the constitutional provision says and what the statute says is that local government has those home rule powers, and zoning is the fundamental home rule power unless they're expressly prohibited or precluded by law, Your Honor. So we don't, in sum, we think there's clearly jurisdiction, as Judge McHugh found. We clearly no express preemption, clearly no implied preemption. This is not the time for an appellate court to make a second implied preemption one. This is not a Public Records Act case, and there's no conflict, because a conflict, in order to be an unconstitutional conflict, has got to be clear and irreconcilable conflict, and there's just not that. And just because a state permits something doesn't mean that local government may not go further. And three examples, if I may, and then I will close. And for example, here, admittedly, the Sanibel rule, as it's applied, which is a prohibition, is more strict than the state rule. That doesn't mean that there's a conflict. The state statutes say that sexual predators may live within 1,000 feet of certain schools, playgrounds, libraries, etc. Many, there's about 5 or 6 cases, if you include circuit court cases, and at least a third DCA case, I think Calderon, which is in our brief here, that says that local government had a 25-foot restriction, 2,500-foot restriction, basically keeping sexual predators out further from those areas. That's not in conflict with the state statute. There's a case involving billboards as well. State of Florida says 20 feet off highways. Local government, because they want to protect the aesthetics, which is the legitimate purpose of the zoning power, 200 feet off property, not a conflict, again, more restrictive. And the third case, and basically had to do with certain employment practices. State of Florida says they apply if you have 15 or more employees, you've got to comply with certain practices, can't do certain prohibited things, and the local government said, no, we're going to make that tighter and go to 5. Just because the state permits something, or may permit something, doesn't mean that local government exercising its home rule powers must permit it as well. Zoning power is very broad, Your Honor.
Okay.
Thank you.
Thank you.
May it please the court. The idea that the home rule power includes the power to negate and prohibit authority and conduct that has been expressly allowed for by the state is belied by an examination of the delegation agreement in this case. I would urge the court to look at this delegation agreement wherein the state DEP tells the local government here, Hillsborough County, there's more than one, but this is the example that's used, says that we're going to delegate, as we're allowed to do pursuant to the statute, the authority to regulate certain things that normally we would regulate, normally that the state would regulate, but we're going to give it to you as is provided by the statute. However, we're going to reserve any and all authority over activities that are to be conducted on our own sovereign submerged lands. You have no authority to regulate or to permit or to prohibit those types of items. If the county, which is a charter county and has home rule powers, has the authority to prohibit those docks, those activities on sovereign submerged lands on their own, the delegation agreement or the entire process of delegation makes no sense whatsoever. Again, if anything, according to the city's concept of this case, it should be the city delegating the authority to the state to regulate these kinds of activity on sovereign submerged lands. Again, the entire concept of delegation, and it's extensive. There are thousands of words in the Florida statutes and the Florida Administrative Code that govern this concept. A county or a city has to make an entire litany of showings as to their fiscal and staffing and technical capabilities in order to be delegated these types of authorities. It's rendered a nullity if they have these powers anyway. And the delegation agreement, the entire concept of delegation, makes no sense whatsoever. Regarding 403.813, that chapter also applies to items such as multifamily docks, which do not, the rules for which do not apply here. So the idea that 403.813 talks about activities under this chapter, you have to look further into the specific activities that are discussed. The rules for single-family docks, which are at issue in this case, are entirely different from those of multifamily docks and other activities on sovereign submerged lands that are governed by that chapter. Another important point is that where the city talked about a one-size-fits-all rule, DEP has the authority and has exercised the authority that when it wants to render a certain portion of its sovereign submerged lands off-limit for docks, it can do so. A case that's referenced in the briefs is Kreider versus Childs from 1993, where an owner of property upland from sovereign submerged lands argued that DEP had no authority to prohibit his dock. And DEP, to the contrary, said, yes, we do. It's our land and we have that authority. And the courts upheld that authority on behalf of the state. So where the state recognizes that there's some sort of environmental concern that requires the prohibition of docks, it itself can do so. Moreover, in other instances of activities conducted on sovereign submerged lands, and I would argue that this is quite important, such as leases of property, such as oil or mineral rights, the state has, the legislature and DEP through the regulatory process has explicitly said we require a showing of compliance with local government authority, with local government zoning regulations before we're going to grant you this right. Again, the fact that it does make that request or that demand in these instances illuminates the fact that it does not make this demand in the authorization for the docks in this case. One final item that, Your Honor, you asked about the upland land or whether any of the docks would be built on upland lands. There is technology that is not provided for in the ordinance of 1993 that's developed since then or was even in effect then, has been refined since then, that allows for what are called floating docks. Docks that will not encumber the upland property but will be built exclusively on sovereign submerged lands. And those too are prohibited by the ordinance.
All right.
Thank you.
Very much. That concludes our docket today, and court's adjourned.